Hey everyone, this is Jeff Fowler with the Apartment Owners Association. It is great to have you with us today. And today we are going to cover the LA County, LA City, and maybe a little bit of the statewide tenant protections. And so you'll definitely want to, if you're in Northern California, next week, next week we're going to have a live stream and specifically address the statewide, Berkeley, Oakland, and address your questions as well. So next week would be the best time to tune in. And all that is coming up. And AOA, here we are, one of the largest individually organized groups of apartment owners in the state. And our purpose and our goal is to help you to be successful. And so that's what we're trying to do with every single thing that we do. And so today we just must know information for you if you're in LA County. And so we're really excited to have a expert with us today. And one thing that AOA does is we do have a magazine, and it comes out every month. And our speaker today, he writes an article, and actually he's been writing 2 articles from what I've seen a lot of the times lately. And at the bottom of the live stream, we will have a link that links to all of the articles that he's written with AOA. And of course, some things will be outdated, but his legal Q&A is excellent and it's always worth reading. And anyway, last week, you may have missed it, but we had a resident manager lawsuit live stream, and we had a resident manager attorney, and we had a owner attorney. They got together, shared their perspectives, had a little disagreement, but it didn't get heated, fortunately. But anyway, if you missed that one and you have a resident manager, you want to watch it, because there's just some key things just to make sure you have those in place. Things you may not have known, but definitely watch that one. 1 o'clock today, we have update on the California rent relief program. The section chief for the California Department of Housing and Community Development will be with us, and so she'll share an update. And then next week, how to attract 67% more potential tenants for free, and also like that Northern California legislative update like I talked about. And anyway, closed caption. If you want closed caption, go to Facebook and that'll get it for you. And also, like normal, if you were coming in, we have you ask one question and then go to the end of the line. So please just ask one question, because we know that there'll be so many questions today. We're not going to get to everything. So save your question and put the best one that you have up. We'll try to get to it. If you're watching this on AOAUSA.com, there's a blue help button. You can put your questions in there. But I highly recommend to not put questions in yet, because after Dennis speaks, you'll probably have a different question, and then you just wasted that one good question that you had. So hold on to the questions until after, and then that's when you'll want to do it. And I kind of leaked out who our speaker is today. And he's been in the business for 45 years. He's done over 200,000 evictions. He's got at least 25 attorneys working with him. 20 attorneys working with him. And so he's up the number there just because of the crazy demand that we've had. And he is a landlord himself, and the founder of the law office of Dennis P. Block and Associates. It's my pleasure to introduce to you today, Dennis Block.
Jeff, thank you so much. And kind of interesting, this couch procedure we have here. It's actually the first time I've ever done a seminar where I'm not standing, so I guess I'll be more relaxed today. But we'll see if we like this format. Yes, I am Dennis Block, and my firm has been representing landlords for the last 45 years. We've seen everything that you can possibly imagine in that time. But right now, with the coming of the pandemic, and even though the pandemic is pretty much over, we're seeing legislation that truly has been horrific with regard to how landlords are being treated, and literally cases and laws that are so far against the Constitution, where landlords are literally singled out and forced to be the financial benefactors for their tenants, like it or not. But that's where we are right now. And so the issue really is that what can we do about it? And I'm happy to report that things are opening up now. That come April 1st, tomorrow, we have a lot more possibilities of what we can do in terms of enforcing our property rights, which is all we're talking about. Our property rights, our contractual rights, where, call me silly, you rent out a unit under a contract and you expect to get your rent, and politicians, for example, in the city of Los Angeles are telling you that you cannot enforce your property rights, your contractual rights, for 37 months. 37 months you cannot enforce your rights. Now, how is that possible? Who in this system, or who in business or in any industry, could be selling and marketing their goods and services for 36 months and not get paid? But that's, of course, what the city of Los Angeles certainly has done. But I've got some ideas and a way of enforcing our property rights, and what we can do to literally rid ourselves of tenants who have no concept that they are going to pay your rent. So what can we do? Well, first, and we have to be, there's much confusion because there's really three different jurisdictions that we have to be concerned about. So if I'm talking about the state of California, I'm not necessarily talking about the county of Los Angeles, and I'm certainly not talking about the city of Los Angeles. So as we can move over to my PowerPoint presentation, what we have is that you have to first determine what jurisdiction you're under. And there's really three. There's the County of Los Angeles, the City of Los Angeles, and if you're not involved with either the County of Los Angeles or the City of Los Angeles, then you need to be involved in the State of California. So let's take the state first. Again, when I talk about the rules regarding the State of California, I am not talking about property located in the County of Los Angeles, and I am not talking about the property that is located in the City of Los Angeles. So right now we're just talking about the State of California. So where would that be, for example? That would be Orange County, Ventura County, Riverside County, San Diego, San Bernardino, Ventura. If your property is in those jurisdictions, you can bring forth an eviction based on non-payment of rent. What you would do is, if the rent is owed from October 2021 through March of 2022, which is today, the end of March, you can bring forth an eviction. You have to serve a 3-day notice to pay rent or quit. That is the 2-page form, which on the second page of the form that the association has, it's going to talk to you about applying for housing relief under the website housingiskey.com. So the first thing you need to do, if in fact rent was owed under the state rules for the period of October 2021 through March of 2022, you need to apply for the California Housing Rent Relief, and that's by going to a website called housingiskey.com. By going to that website, you're going to apply. Now, once you apply, you have to wait 20 days before you can file an unlawful detainer. So you could serve a 3-day notice for that period of time using the new 3-day notice form. I call it a 2-page notice form. and then apply, wait 20 days, and then you can file the unlawful detainer action. Now, the problem that we have under many jurisdictions is that you cannot file a default, continue on with the case, unless you get a rejection from the California Rent Relief Board. So in other words, that if your tenant didn't apply, for example, you applied but your tenant, then technically the Rent Relief Board should give you a rejection. Or if the tenant doesn't qualify based on the information that was supplied by the tenant to the board, then they should give you a rejection. Unfortunately, what we found in many cases is that the Rent Relief Board never gave a rejection. They just say action is pending. So on that basis, we can't really go forward with the unlawful detainer to finish it. Now, we have been submitting documents or declarations to the court saying, hey, the tenant didn't apply, and please allow us to proceed forward with a default. But in those cases, we've been a little bit hit or miss whether the courts are allowing us to finish this case. So, seeking rent for the period of October through March and then trying to file an unlawful detainer on the state level, and I'll get into the County of LA and the City of LA later, is a difficult process. We can do it, but unless you get a rejection, then our case is going to get stalled. Now, in some counties, we're finding that the rent board magically gives us a rejection. Technically, the tenant is supposed to, once he's been invited to apply, has 15 days to do so. And if he doesn't, then technically the rent board should give a rejection, which means we can go forward with our lawsuit. But unfortunately, that's not what the case is. In some cases, we're getting it, some cases we're not. And then in those cases where we're not getting it, we try to do a declaration by the landlord, which indicates that the tenant hasn't applied, but we still haven't gotten the rejection. And we hope at that point that, in fact, we will actually have the court allow us to take the default. Now, if you're under the state jurisdiction, if you're not subject to any rent control whatsoever, you need to, number one, serve on your tenant a notice saying this property is not subject to any rent control. So, for example, if I have a single-family home in Orange County or in San Bernardino or Ventura, I need to serve on my existing tenant a notice that this property is exempt from rent control. By the way, all these forms are available from the AOA at no charge. If your property, if you're renting out a unit that is not subject to rent control, then that phrase has to be contained in the rental agreement. So I'm cautioning everybody, if your property is not subject to a local jurisdiction like Los Angeles or unincorporated areas of the County of Los Angeles, when you rent out a property that's not subject to any rent control at all, because it's either a condo, a townhouse, new construction within the last 15 years, or a single-family residence, that's got to be contained as a phrase in your rental agreement. If you don't have that, then you're going to be subject to statewide rent control, which is going to put a limit on your rent increases and also is going to require good cause to do an eviction. So make sure that that phrase, again, if you're not subject to any rent control, that phrase is there. Now, if you're not subject to a local jurisdiction and your property is therefore subject to statewide rent control or not subject to statewide rent control, then you can proceed to terminate tenancies having nothing to do with rent. So, for example, if you're not under any rent control at all, again, you're a single-family home, a townhouse, new construction, you can serve right now today a 60-day notice to vacate. So if I have a house in Chino, for example, and the tenant is on a month-to-month and he's been there longer than 1 year, I can serve a 60-day notice. I'm not subject to any rent control whatsoever. If I am subject to statewide rent control, then I have to have good cause to evict. Good cause would be, for example, well, failure to pay the rent, that would be one, but also for violations of the rental agreement. For example, I had extra people there in violations of the rental agreement, or I brought a pet in, or I've done some alterations. These are all proper grounds that are under the state-wide rent control for eviction. If I'm not under any rent control, just serve a 60-day notice on a month-to-month tenancy for tenants being there longer than 1 year. So that's basically it for statewide rent control. Be sure that if you're subject to the state and you're not subject to any rent control, that phrase is located in your rental agreement, or a notice is given to existing tenants. If somebody is moving in, that's got to be contained in the rental agreement. Technically, if your property is subject to rent control of statewide level, then that phrase again has to be in your rental agreement that it is subject to it. And also for existing tenants, you have to serve a notice on your tenant saying, yes, this property is subject to statewide rent control. But as of April, for statewide rent control, or for property not subject to any rent control, April's a whole new animal, ladies and gentlemen. While we have limitations when it comes to rent that's owed from October to, let me move this slide over, from October to March, I've got to apply for rent relief. I've got to wait 20 days, and then eventually I can't finish the eviction case until I get a rejection from the board, and whether I get it or not is another story. But in April, it's a whole new ball game, ladies and gentlemen. If my property is not subject to LA County, not subject to the city of LA, I can serve the old standard 3-day notice form, a 1-page form, making a demand for the April's rent. When can I serve that? I could serve that on April 2nd. So if you've got a tenant who hasn't paid you rent, and we're in the city of Orange, or you're in the city of Santa Ana, or you're in the city of San Bernardino, on April 2nd, if that tenant hasn't paid me rent, I can serve the old standard 3-day notice form, and I can start an eviction after the 3rd day. Now, be sure that your old 3-day notice forms has that phrase in it. Again, you can get this from the association, where it states specifically in the form that Saturdays, Sundays, and legal holidays do not count as part of the 3 days. That phrase has got to be in your notice. If it's not, then write it in yourself. Once again, Saturdays, Sundays, and legal holidays do not count as part of the 3-day notice period. So you're going to serve that standard notice outside of LA County. You're going to wait 3 days, and then if you don't have your rent in your hand, then again, you could serve it as soon as Saturday. Now, even though the tenant might owe you a bunch of money before, we're going to limit that just to April's rent. So serve that on April 2nd or April 3rd or whenever you get around to it. Or if he pays you April's rent, then do it in May, and then you can commence an unlawful detainer based on failure to pay the rent. The Rent Relief Board does not pay for rent past March 31st. And I've been informed that you can't even apply for rent relief after today. So today's your last day for any rent owed up until March 31st. But for April, they weren't paying it anyway. So get your dusty 3-day notices out and get ready to serve it just for the April's rent as soon as April 2nd. Again, make sure that your rent, your total notice, the 3-day notice states specifically on it that The Saturdays, Sundays, and legal holidays do not count as part of the 3-day notice period. Please get that form from the association, and you'll know that it's always up to date when you use those forms. So that's where we are with regard to anything outside of LA County. LA County and LA City have their own rules, and we're going to get to that soon. But that's what's required for the state rules, excluding the county of LA. So let's move on my chart here. I think I finished what I needed to on this. Okay, now we're moving over to LA County and the rules dealing with Los Angeles County. Now, a city called Redondo Beach is located in LA County, and a city called Manhattan Beach and Culver City and Pasadena are all located in LA County. But when I'm talking about LA County right now, I am excluding the city of Los Angeles. I'm going to hold that to the end, ladies and gentlemen. And I do have a new trick that we're going to tell everybody now for the first time of how we're going to deal with that wonderful city of LA County. Excuse me, LA City. But what I'm talking about now for LA County does not include the city of Los Angeles. I'm going to say it like 5 times because every time I get this, then they call my office and they get this wrong. So the rules relating to LA County do not apply to LA City. So what are the rules relating to LA County? The rules relating to LA County for any rent owed from October 2021 through March of 2022 are the same as the state law. That is, you serve that 2-page 3-day notice form. You have to first apply for housingiskey.com for the rent relief. You have to wait at least 20 days from when you apply, and then you can file your unlawful detainer action. But again, you can't finish the unlawful detainer action. You can't take a default if, in fact, you don't have a rejection from the California Relief Board, and they're reticent to give you a rejection, even though the tenant hasn't done their part. And even though the law says it should be rejected, it doesn't make a difference. So we're getting very few rejection forms, and that's where we're coming up with this declaration from the landlord, which basically says the tenant hasn't complied. And some courts have been giving us judgments, and a lot have not. So that's the story with regard to rent owed in the county of Los Angeles from the period of October 2021 through March of 2022. But ladies and gentlemen, right now, as of tomorrow, it's April. And there's no basis of applying for rent relief anywhere in the state of California for April's rent and thereafter, because the Rent Relief Board doesn't continue to the month of April or thereafter. But the county has a different rule. So where in the state I'm saying, hey, serve your notice on April 2nd and let's start that case in 3 days. I can't tell you that for the county of LA because they have an additional rule. And that additional rule states that if the tenant does a self-certify that he has an inability to pay the rent because of COVID, then you cannot proceed forward with an eviction for the April's rent. So while you would be serving a standard 3-day notice, which again has to have that phrase, doesn't include Saturdays, Sundays, or legal holidays. But while you can serve that standard 3-day notice, you can't do it if the tenant does what they call self-certify that he has an inability to pay rent because of COVID. But the county put a time limit. The tenant has only 7 days from when the rent became due to self-certify. Well, what the hell does that mean to self-certify? Self-certify means that the tenant in any way, shape, or form communicates to you that, hey, I can't pay because of COVID. No documentation is required. Well, what does that mean, communication? That means that the tenant has to call you, text you, whisper it in your ear, send a carrier pigeon, smoke signals. In other words, that the tenant has 7 days from the due date of the rent. And that's just not for April. That would be for any succeeding month. So let's pretend in May. He'd have 7 days from May 1st to self-certify. If he doesn't, then you're free to serve a 3-day notice and proceed forward with your eviction. So you don't want to, ladies and gentlemen, serve a 3-day notice on April 2nd. We want the trap to already be engaged. So what does that mean? We want to wait 7 days, and then after the 7th day, we're going to serve a 3-day notice. And I actually put another phrase into our notices, which will say, we have received no communication from the tenant as to the reason why April's rent wasn't paid. I put that phrase right into the notice, and we have these notices to go. So when is the first day you can serve a 3-day notice in the county of LA? And again, excluding the city of LA, when's the first day we can do that for the month of April? Well, based on the fact that there's a weekend coming, it's April 11th. So on April 11th, I have about 40 to 50 3-day notices perched, ready to go. If the tenant does 2 things. Number 1, hasn't paid me April's rent. And number 2, hasn't done the self-certifying. That is, communicated it to the landlord. Now, if anybody out there has a tenant who hasn't paid rent for months, we all know exactly what the tenants do. And that is, they do nothing. It's radio silence. They don't communicate anything to you. I mean, you can bug them for the rent, but unless you talk to them, they're not talking to you. And no tenant's going to know to self-certify. So in almost every case in the county of Los Angeles where our tenant is not paying rent, we have the right to proceed forward with an eviction by serving that standard 3-day notice form on April 11th. So outside the county of LA, April 2nd. Inside the county of LA, April 11th. And for May, it would be whatever that is, 7 days after the due date. For June, 7 days after the due date, because they have to do it for each month. So we can now basically enforce our property rights in the county of LA, excluding the city of LA, for anybody who fails to pay rent for the month of April. Now, what about all that rent they owe for about 12, 13, 14 months up until March 31st? Your only remedy really is housingiskey.com, and pray that you get the money for them. Otherwise, you're going to have to wait at least a year to get your money by filing a regular civil lawsuit. But for rent owed for the month of April, if that tenant doesn't tell you, you have the right to go forward. Now, in the unlikely event that the tenant does self-certify, then you can't go forward with an eviction for the April's rent. And you have to just file a civil lawsuit, and you have to wait 1 year to do so. 1 year to do so before filing a civil lawsuit for that rent. But I can tell you, ladies and gentlemen, that in almost 100% of the cases, your tenant's not going to self-certify within 7 days of the due date. And on that basis, you can proceed forward. Now, you always, in the county of Los Angeles, excluding the city of Los Angeles, could evict for other reasons. You can't do what they call a no-fault eviction. Like, this is a single-family home. I want to sell my property. Please get out. You can't do that. You can't, unlike in the state where I want to renovate my property. Under the state law, I'm allowed to serve, even if your property is under statewide rent control, I can serve a 60-day notice that I want to renovate the unit. And you get the tenant under that circumstance is entitled to 1 month's rent. And I renovate the unit. Renovation means that it has to take at least 30 days to comply or to complete, and also that it requires a building permit, like an electrical or plumbing permit. So basically, you would just be changing the kitchen or changing the bathroom. And then even if it's under statewide rent control, that's a wonderful reason to evict. If you're not under any rent control, then of course you can just serve a 60-day notice to vacate. But under the county rules, even if you're not under any rent control, I got a single family home in Manhattan Beach, I normally could serve a 60-day notice to vacate. Or if I have a property in Manhattan Beach that's subject to statewide rent control, I could do a 60-day notice based on renovation. But right now in the county, you're forbidden from doing that. Now, you can ask a tenant to move in the county of Los Angeles if you're going to put in a close family member. That would be a grandparent, a spouse, a child, or a grandchild. You have to pay substantial relocation money, anywhere from about $8,000 up to about $17,000. And that's true whether your property is not under rent control or not. Under the county rules, if you wait till January of 2023, then you're not subject to any county rules anymore, and you can ask any tenant to vacate who's not subject to rent control and just pay 1 month's rent. Or you can do your renovation eviction in January of 2023 under the county rules. They have different phases in their rules dealing with property, and there's the phase 2 deals with property from June 1st to January. But the bottom line is you're going to basically have to wait till January of 2023 before you can just merely ask a tenant to move because you want to sell the property. Otherwise, unless you have some other good cause. But you can always evict in the county of Los Angeles for violations under the rental agreement. That would be pets that are in violation of the rental agreement, unauthorized occupants, alterations to the premises. These are all proper grounds. And of course, you can always call our office and run it by me, and we can tell, or one of my attorneys can tell you whether you have proper cause under the county of Los Angeles to evict. But again, for most landlords who are suffering for non-payment of rent, where the tenant hasn't paid in 13 months and will continue not to pay for the month of April, well, we know we're just going to go after April's rent in the county of LA. We're going to wait until April 11th, because by then it's too late for the tenant to self-certify. We're going to put that phrase in our 3-day notice that the tenant has not communicated with me as to the reason why rent was not paid. And then we're going to be able to serve that 3-day notice and proceed forward with an eviction. So that's basically it for the county of LA. And we have a lot of possibilities for evicting for violation under the rental agreement. We can't do a no-fault eviction. We can put in a family member if we're planning on paying substantial relocation, anywhere from $8,000 to about $17,000, regardless of the rental property. Now, before I leave, I want to also talk about commercial. For outside of LA County, you can evict any commercial tenant for not paying the rent. Serve a 3-day notice for any rent that they owe you within the last 1-year period and proceed forward with an eviction. If that tenant is on a month, 2-month tenancy, you can just serve a 30-day notice on any commercial tenant and ask that tenant to leave. In the county of Los Angeles, for commercial tenants, you can serve a 3-day notice for any rent owed, but it has to be just from February 1st, 2022 forward in time. So if you have a commercial establishment or even a parking space, that would be considered commercial, and the tenant hasn't paid you, you can serve a standard old 3-day notice form. Again, you should always have that phrase in it, excluding Saturdays, Sundays, and legal holidays. And from February forward in time of 2022, we can evict that commercial tenant. Right now, today. Okay, let's move on to the city of Los Angeles. That's a good one, ladies and gentlemen. The city of Los Angeles basically has taken all your property rights, thrown them out the window, and expect landlords merely to rot. That's exactly what it is. Their statute says that you can basically go about 37 months without paying any rent to your landlord, and the landlord has zero, count it, zero ways to enforce your property rights. You can't bring a civil lawsuit. You can't hire my wonderful law firm to do an eviction. You're basically waiting only for rent relief from the California Rent Relief Board, but that expires today. So what happens in April? Well, ladies and gentlemen, the City of Los Angeles moratorium continues until April of 2023. Well, that's another 12 more months. So what am I supposed to do? It's very simple. You're supposed to rot, because the tenant might have already owed you about 24 months worth of rent spanning back from March of 2020. Now we're already in March of 2022. That's 25 months. And now what we're going to get is another 12 months. So you might have gotten some rent relief from the California Rent Relief Board under that website called housingiskey.com. But what if the tenant didn't comply? For whatever reason, maybe he knew he didn't qualify because he's making enough money and was never impacted. Or he just didn't get it together. Or he's vindictive and said, why should I do anything to you? Because I know you can't do anything until April of 2023. So that means landlords are just supposed to lie down and die for 37 months. 37 months, ladies and gentlemen. I don't know which businessman out there other than property owners can expect that they're not going to get paid for their units and still have to pay their mortgage payment. Don't forget, you're still going to have to pay your property taxes. You have to pay for your sewage and trash for these buildings. And God forbid that something goes wrong with the premises, you have a legal obligation to fix it with no income. So this is insane, ladies and gentlemen. And that's what the city of Los Angeles has instituted. Now, yes, there are lawsuits against the city, and I predict that the city will be on the hook for causing literally billions of dollars of losses to income property owners. Even the city of Los Angeles says that while their statute is over in April of 2023, all that rent that's owed up until that point in time, potentially 37 months, isn't due for another year. Another year. That would mean you couldn't even enforce your rights until April of 2024. So maybe you can get the April of 2023's rent, but you can't go back and file a civil lawsuit until April of 2024? This is insanity, ladies and gentlemen. So I was sitting at my office on, I think it was March 14th. And a client called me early in the morning because they know I get there early. And this client said something to me which triggered an idea which I'm now going to give to you. Also in the city of Los Angeles, you can evict for unauthorized occupants. They can bring in as many people as they want, and even though the water bill is going to go up, you can evict for unauthorized occupants. You can evict for unauthorized pets. You can evict for non-payment of rent if the tenant coughs the word COVID, and there's no way for you to ask for any proof. So you're basically just sitting there and dying. But I came up with an idea that allows in certain cases for you to bring forth an eviction. And boy, are we bringing forth cases on this. But you have to qualify. If you don't qualify, I'm sorry, you're just going to die on the vine, and you got to wait until April of 2023. But if you qualify, then I've got a secret plan to do evictions. And this is what we're going to do. Let's pretend, let me tell you what the criteria is first. The criteria is that your tenant has to be on a month-to-month tenancy and not subject to the rent stabilization ordinance. So you're in the city of Los Angeles, your property is month-to-month, it's not on a fixed-term lease, and you're not subject to the rent stabilization ordinance. So therefore, your property would either have to be a townhouse built after, or a condo built after October, or in a multi-unit apartment building built after October 1978, condo, townhouse, or a multi-unit building or a duplex built after October 1978. So that's one that would not be subject to LA rent control. A single-family home would not be under LA rent control. So assuming that you have those, then you have the right to use my idea. So let's move over to my new idea. Okay, so once again, it applies to single-family homes or commercial units. Commercial units would not, again, be under LA rent control. That's only for residential. Townhomes, condos, and multiple units that are built after October 1st, 1979. So if you have that property and your tenant is on a month-to-month tenancy, this is how we're going to evict. I'm going to give you an example. Let's pretend that the rent is $2,500. And when the tenant moved in, he paid a $2,500 security deposit. Very common. The tenant is now on a month-to-month tenancy. Now, you're not subject to rent control, so you certainly could raise the rent, but really that's not going to assist you in the city of Los Angeles, because if the tenant's not paying any rent, so if you raise the rent, what good is that going to do? So if I raise the rent to $3,500, he's still not going to pay it, and I still can't evict, because I can't evict for non-payment of rent. But under California law, ladies and gentlemen, I can request, under California law, that I get a maximum of a 2 months security deposit for an unfurnished unit. Now, most units in California are unfurnished. So if I rented this unit out and I charged a $2,500 first month's rent and a $2,500 security deposit, I did not charge the full security deposit. And if I didn't charge the full security deposit, then I can do what they call a 30-day change of terms of tenancy, increasing the security deposit to 2 months' rent. So right now, Mr. Tenant or Mrs. Tenant, I am now requesting in 30 days that I get a $5,000 security deposit. Now, you've already paid me $2,500. So in 30 days, I want an additional $2,500 security deposit. And if you don't pay me $2,500 after the 30th day, then I am not going to serve you a notice to pay rent or quit, because I can't. But I can serve a notice to perform or quit. That's not rent. I'm not asking for rent. This is not a rent. This is not a fee. This is an additional security deposit, which I have every right under California law to request. So I'm going to serve you with a 3-day notice to perform or quit, giving you 3 days to pay the additional security deposit. If you don't, I'm then going to commence an eviction, and I have every right to do so. I'm not evicting for rent. I'm not evicting for extra people. I'm not evicting for unauthorized occupants. I'm evicting on the basis you didn't pay me the additional security deposit. The particular case that gave me this idea was a house in Los Angeles where the tenant, so it's not under rent control, the tenant's on a month-to-month. The tenant moved in, paid a 1 month's rent, paid rent for a couple of months, and then claimed COVID. The rent was, ladies and gentlemen, $15,000 a month. The tenant paid a total of $30,000 to get in, $15,000 for the first month's rent and $15,000 for the security deposit. We have already served this tenant with a 30-day change of terms of tenancy, increasing the security deposit to $30,000, which I have the right to do under California law. And this tenant in 30 days has to pay the difference, which is $15,000. Let's take a look at the math. There's the math. In my example here, I was using a scenario where the rent is $1,350 per month, and the tenant paid the first month's rent and a $1,000 security deposit. Well, in that situation, I could have asked for a $2,700 security deposit. And if that was the case, I could serve a 30-day notice asking for a total of $2,700 minus the $1,000 that the tenant paid, and in 30 days that tenant has to pay me $1,700. If the tenant doesn't pay $1,700, I'm going to serve that tenant with a 3-day notice to perform or quit to pay the $1,700. If he doesn't, I'm going to start an eviction based on a breach of a covenant to pay that rent. Now, we can play with these figures. Now, the worst that's going to happen for my client with that home for $15,000 is that the tenant pays it. I doubt he will, but then at least the landlord has $15,000. And the same thing even in this example that I'm showing you here. Maybe the tenant's going to come up with $1,700. But then I have another plan. Maybe this property is under market value. Maybe it's really worth more than $1,350, as in my example. Or even in that house, maybe the house really is $18,000, not $15,000 market value. So I'm going to serve on that tenant a rent increase notice first. If I'm going to go above 10%, then I got to serve a 90-day notice. If I'm going to go 10% or less, then I'm going to serve a 30-day notice. But once that rent is increased under the city of LA, COVID, I don't have to pay the increased rent. No matter what, whether 90 days, 30 days, I'm not paying. I don't have to pay anything until April of 2023. But you see, if I have increased the rent, now I have the right to increase the security deposit. So if I increase the rent on that house for $15,000 to $18,000, an extra $3,000, I could then, once that rent increase kicks in, I can then increase the security deposit. Now, the security deposit, if the rent's $18,000, I could get a $36,000 security, less what you've already paid me. So it seems like I can get another $6,000 security deposit at the end of my 30 days. And then I would serve an additional notice on them. So you can play with this example, but the bottom line is, if you qualify in the city of Los Angeles, as opposed to rotting in the field until April of 2023, if your property is not subject to RSO, if your property is on a month-to-month and located in the city of Los Angeles, I think it's time to raise the security deposit. If you got a maximum security deposit when you moved in, hey, I already got a 2 months rent deposit, Dennis, so I can't ask for an additional security. Well, you can, because you're going to raise the rent, and then once that rent is increased and kicks in, so now the tenant legally owes me more rent, then I can serve a 30-day notice to change the terms of the tenancy to ask for the additional security deposit. So that's a plan that we're doing at our law firm. And I predict that we'll be able to rid ourselves of these tenants. Drastic times calls for drastic measures. Nobody would be doing this except the city of Los Angeles is forcing landlords to take these extraordinary steps because the city of Los Angeles is expecting landlords to go, 37 months or longer without receiving any revenue. So we're just taking what the city is giving us. So there's nothing improper about what we're doing. The only thing that's improper, ladies and gentlemen, is the trampling of our property rights by the city, who expects us to sit there and rot in the field for that 37-month time. And Jeff, that's my plan. If anybody wants to talk to me, obviously, you can call my office. I'm sure that our number will be on the screen. But why don't we open it up to questions now? I'm sure there'll be a few on this topic. But again, ladies and gentlemen, remember that there's a difference between the state, the county of Los Angeles, and the city, okay? So let's open it up to questions.
All right, thank you, Dennis, so much. And before we open it up to questions, I think we have a sponsor that we're going to hear from. So you guys can go ahead and roll that, and we'll be back with you here in a second.
Hello there, AOA members. This is Daniel Sharabi, CEO of Livable. We've been partnered with AOA now for some years to bring our ratio utility billing services to membership. And what really sets us apart, aside from quality service and taking great care of your residents and billing them back fairly and accurately for their fair share of utilities, is that we have no minimums. So that means if you've got a duplex or a single family home with an ADU, we're happy to help facilitate the utility bill back on your behalf. So we would love for you to get in touch and join all of these happy customers in using our service and celebrating conservation, but also increasing your net operating income. Livable.com/AOA is where you can find more information and ways to get in touch with us. We look forward to getting some time scheduled and to telling you more about the program and how you can do your part to promote conservation. All the best and enjoy the live stream. Hello there, AOA members. This is Dan.
All right. Thanks, guys. And again, this is AOA. And if you missed us at the very beginning, just real quickly, someone go run and get that one, please. Let me see here. Okay. So right now is when you can type in your questions. So go ahead and type those in. If it's the blue help button, type in your question there, and we're going to get to it. And just before we do, if you appreciate Dennis, if you think this is good, What I want you to do is to share this with the other housing providers that you know. Share this YouTube with them, and that will help get the word out. And it's important for people to hear what they can do. So please get the word out by sharing it with other people. Copy and paste that link into an email, or just hit the share button if you're on YouTube, and get it out there, and that'll really help. And again, closed captions on Facebook, and also it'll be on YouTube after the fact. And last week we had a resident manager lawsuit thing. Definitely you want to see that. At 1 o'clock, we're going to hear from someone that works at Housing is Key. She's a section chief for the California Department of Housing and Community Development. So you can ask her questions. That'll be really good. Next week, how you can attract 67% more potential tenants for free. Nothing is being sold on that one. That is just one of those ideas. Again, we're all about giving you ideas on way to set you up for success. That's what we're trying to do. Next week, we're going to talk about Northern California. We'll have a Northern California attorney speaking about state and then the local things in Northern California, Berkeley, Oakland, those areas. So that's what's going on. So here we go now to the questions. In the chat, we have Yolanda. I have a Section 8 applicant who's waiting for an inspection of a unit in order to be qualified. Can I charge Section 8 for the days the unit is off the market? Dennis.
The answer to that is no. They're only going to pay for when the tenant actually occupies the unit and the tenancy starts.
All right, Facebook. Just to be clear, in LA County, as of April 1st, 2022, any tenant that claims to be impacted by COVID within 7 days does not get evicted, even if they did not apply or qualify for rental assistance. Is this correct?
That is correct. The term that the county came up with is self-certify. So in any way, shape, or form, they say, hey, I do not have the ability to pay the rent, and it's directly related to COVID, then there's nothing that you can do in that situation. You have to wait. But again, it's got to be within 7 days. I'm really thinking that it's going to be unlikely that tenants will, quote, no to self-certify within 7 days.
Great. Okay, Peter on YouTube. In LA County or AB 1482, what do you do if we have only one person holding the rental agreement and the tenant suddenly brings in 4 children?
Well, the rental agreement would probably limit who can live there. So on that basis, you could serve a 3-day notice to perform or quit to get rid of the unauthorized persons. However, if they're all his children, would be the question. If they're his children, I would not do that case. But if they're not his children, then I think you would have the right to bring forth an action based on a violation of the contract.
Okay, great. All right, in the chat, Ross, City of Los Angeles. Ross, you know how to ask questions, so good job. City of Los Angeles, single family home. When you guys are writing your questions in, you got to tell us where it's at for sure, just like this. Way to go, Ross. Single family home and just added an ADU. The ADU is the ADU under RSO because it is attached to the house, or will it fall under AB 1482 after the 15th year of certification?
If it's physically, if the ADU, which stands for accessory dwelling unit, is physically attached to the house, for example, there was a garage that's attached to the house and you converted that, that's going to be part of RSO, the Rent Stabilization Ordinance. If it's a separate house in the back that you converted to an ADU, then that will not be part of the city at all, ever, unless they change their rules, because it was built after October 1979. It will, in 15 years, become under statewide rent control. And so, but the curious part is that your single family home, which was never under rent control, magically becomes under rent control because you're under RSO, because there's 2 houses on 1 lot, and the single family home presumably was built prior to October 1st, 1978.
Great. Okay. On YouTube, Victoria, if I receive subsidy money that is greater than the rent that the same tenant owes and I don't want to keep the tenant, what can I do?
I would need to know where we're talking about. If you're not in the county of Los Angeles and the tenant's on a month-to-month, and assuming you're not subject to any rent control, then you would be able to just ask the tenant to move by serving a notice to quit. If you're under statewide rent control, or you're under LA County rent control or city rent control, you're going to have good cause to evict.
Okay, all right. Facebook, Mary, can we raise the rent more than 10% for units that are exempt from AB 1482 and that are not under other stricter local ordinances?
Okay, so you are allowed to raise the rent to market value, and everybody quotes this code section, Penal Code Section 396, which talks about anti-gouging, and it's a criminal offense if you go above 10%, because that could be a gouging and you're committing a criminal act. But if you read the statute, it says gouging is defined as going above market value. So that's like, when you sell a bottle of water during an earthquake, for $50, that's gouging. But if you can justify the rent that you want to charge for a single family home, which is not subject to any rent control, and you did a rent comparison, maybe you went to apartments.com or other locations, and said, hey, this is a normal rent for this type of unit, then you can go above 10%. If you do go above 10%, in order to do a rent increase, you'd have to serve a 90-day notice to change the terms of the tenancy. If it's 10% or less, then it's a 30. In other words, there's no more 60-day notices to increase rent anymore, ladies and gentlemen.
All right. And next question. All right. In the chat, Vicky, how can we tell when a county has a price gouging protection still in place, and if the restriction applies?
That's a state law, anti-gouging, so it applies everywhere, not necessarily just housing, but to everything. And, which reminds me that I had to pay a bunch more money for a brand new car that I bought because there was a limited, and I had to pay extra more than the sticker. And I was thinking, isn't that gouging? But the truth of the matter is that it was market value for the car, because obviously demand versus supply. And so it wouldn't fall under the anti-gouging provision for that. But the bottom line is that as long as you can justify, there's another website that I don't mind talking about. It's pronounced differently, but I pronounce it rentometer.com. Mm-hmm. That's spelled R-E-N-T, the letter O, then meter, M-E-T-E-R.com. It's free for the first 5 checks, and you can actually go to rentometer.com, put in the address of your property and how many bedrooms and how many bathrooms. It'll do a comparison in seconds of all the similar houses in a mile radius or a 2-mile radius. So you can get an idea. I recommend that site. And you can get an idea whether you're, quote, gouging or not. I mean, the bottom line is that you can't really charge more than really what your property is worth. So you're safe, obviously, if you do 10%, but if you want to go above, hey, I haven't raised my rent in years, and I know everybody in this neighborhood is charging $2,600, and I'm only charging $1,350, then you want to know something? You can double the rent and go to $2,600.
Great. And yeah, that is a really good site. And even with those numbers, things are moving quickly. Things are being filled really quickly. And here we are. Emma and YouTube, what percentage of eviction cases are you able to move forward with in LA City and LA County?
Not sure what I mean by what percentage. I mean, if you qualify, you qualify. So in LA County, if you're violating a term of your contract, I can generally evict. That's excluding the city of LA. I can evict for non-payment of rent commencing April, unless the tenant's self-certified. And in LA City, again, there's not much I can do because I'm limited to rent, extra people, and for unauthorized pets. I can't evict for those. I can evict for failing to pay a security deposit for those that are not under RSO.
Okay, great. Rebecca, here's a documentation question. For the city of LA tenants that are causing nuisances but cannot be evicted at this time, is it best to send warning notices in the mail to document the nuisances? Are courts considering email or text conversations as documentation?
Well, the premise of the question is incorrect, because if that client had asked me that question in my office, the first thing I would have said back is, you mean to tell me that if a tenant in the middle of the courtyard takes a gun and starts shooting, that I can't evict because of the city of LA? And the answer is, of course I can. If your tenant is committing a nuisance, I don't care where you are, city of LA, county of LA, outside the county of LA, you can always evict for a nuisance. The issue is, does it really qualify as a nuisance? Obviously, if it is nuisance behavior, you're going to need to be able to prove it, which means you're going to need to have other tenants come to court. I took a case in just yesterday where a tenant in the city of Los Angeles in a multi-unit building was caught on video stealing not one but 2 Amazon packages. We called that a nuisance. The tenant, when confronted, took it into her apartment. The tenant, when confronted, denied that she did. Then we have video of the tenant going to the garbage dump, the garbage bin, with a big trash bag and dumping it in. Of course, the tenant who was taking video went over to that trash bag, opened it up, and of course, there were the Amazon boxes inside. So that's a case we're going to start. So the premise of the question is wrong. We can evict for nuisance behavior, but you're going to need to have proof. So if the guy's, doing toga parties into the middle of the night, yelling and screaming and music, and they won't shut up, and you go and you talk to them and they start banging on the walls, even worse, I can't do that case unless I've got some tenants who are willing to come to court to testify that the guys are making my life miserable. I can't use in most cases, I don't need other tenants, but there's a certain percentage of cases when it comes down to the end that I will need to have an actual witness come to court.
Great. Okay, so Ron asked a similar question. What's the best type of documentation for Los Angeles owners who need to show tenants?
Again, I would need, well, in this case, I had video proof that she's stealing packages. But otherwise, I just generally need the testimony of other tenants saying, this guy's crazy. He's looking in my window in the middle of the night. I called the police. Or he's banging on the doors in the middle of the night. Urinating out the windows, I don't know. Loud music, can't just shut up. It's got to have some proof of some people who can testify that their lives are impacted by what the conduct of this particular tenant.
Great. And Lauren on YouTube, my tenant was denied in the city of LA. COVID relief from housing is key. Can I evict now?
No, you can't. Doesn't matter that they were denied, okay? The issue is, as long as the tenant says, hey, I'm impacted by COVID, then you cannot evict under the moronic laws. Yes, that's correct. The moronic laws as promulgated by the city of Los Angeles, which is extending those laws until April of 2023, which brings me to another thought. Jeff, no one is financially impacted today by COVID. Nobody. I don't understand why they've extended this to another year. There's not a human on the planet that's affected by COVID. Let me explain. Maybe about a year ago, maybe you lost your job because of COVID. But call me silly. All businesses are back. Walk into a restaurant, okay? Everything, prices are higher. Employers are dying to fill their vacant jobs. So who's really impacted? Even if you got COVID, you know what that means? It's 2 weeks, ladies and gentlemen, 2 weeks. What do I mean by 2 weeks? Either you're dead in 2 weeks or you're over it in 2 weeks, but you're not financial. You think we'll get payment? We're going to get something on that one now?
I don't care.
You don't care anymore. Okay. You're not going to be impacted financially, okay? So the reality of the situation is nobody's impacted. For these city council persons and for the mayor of the city of Los Angeles to try to help tenants who are financially impacted by COVID through April of 2023, get a life. No one is impacted. Anyone can get a job.
And if they have COVID long, then maybe there's something, that could be something, right? But how many cases are we talking about? We don't need to have a blanket ban on everybody for real specific things. And so, yeah, obvious abuse. We did that survey. We had 260 some odd people respond that were mainly LA County, not LA City. And we're asking for something really specific. So the majority of those were, this guy's just abusing the system.
Every tenant is abusing the system, with maybe the exception of 5%. Maybe 5%. And right now, it's 100%. If you have a tenant, ladies and gentlemen, that are telling you right now, I can't pay because of COVID, I will tell you that every one of those tenants have one thing in common, and that is they're liars, okay? They have every ability, or if they don't have the ability to pay the rent, it has nothing to do with COVID. Let me put it that way. And do you know that, and I said this before, at least once a week, I have 5 clients tell me that their tenants got a brand new car. Well, of course they got a brand new car. The landlord paid for it.
Yeah. Here we go. As we go here, let's see. Housing under LLC in Ontario, San Bernardino County. We increased the rent 5% on 2/1/2021. How much could we increase it again now?
Well, you were entitled to an 8.6% rent increase because it was 5 plus the CPI. The CPI is 3.6%. So you could have increased it, and right now you can actually do 2 increases as any 1 year period. So you can increase it right now by serving a 30-day notice, an additional 3.6%. Now, the CPI is calculated in April of each year, and those calculations come out for your county in May of each year as to what occurred in April. So we might as well wait right now and let's see, because April 1st is tomorrow. Let's wait to May. So anybody who hasn't done a rent increase, let's wait, because I am sure the CPI will be much higher than 3.6%.
Right. All right. Are jury trials allowed now?
Jury trials have always been allowed. They've never been stopped. And it's a popular vehicle for tenants' attorneys to ask for a jury trial, knowing that the case will be more expensive and that the case will be delayed.
Great. And one question I had on your, with your idea, once the tenant does vacate, by law, when do they need to when does the security deposit need to be returned?
Well, once a tenant vacates, the general law is you have 21 days from when the tenant vacates to do an itemization as to things that you can deduct, like non-payment of rent, cleaning, and any unusual wear and tear to the property.
Great. And so I think just good to remember that you have that money, but you're still maybe obligated to give it back, but at least you have it. And
Right.
If they're tearing everything apart, you're going to have something there at least to fix it. All right. And let's see, next one. Armando, tenant ignores rent raises and keeps paying the old rent. Do I reject all and issue a 3-day notice, or just the difference? I tried housing is key, but got rejected. So
Well-
hard question because you don't know where they're at. So always write in where you're at and if it's a multi-tenant or not.
Let's pretend as of April, if they don't pay the correct amount of rent, you have the right to reject it and serve a 3-day notice if you're in the county of Los Angeles, not the city of Los Angeles. You'd have to still wait for him to self-certify, which in this case, it doesn't seem like he's doing it. He just doesn't want to pay the rent increase. So I would reject the rent and I would wait 7 days, and then on April 11th, I'd serve him with a 3-day notice for the full amount of rent.
All right, Fernando, multi-family unit in Long Beach. Rent is due on the 1st, so we'll serve a 3-day, pay rent on the 8th if not received.
Well, but I wouldn't do it on the 8th. I would do it on April 11th because of the weekend there.
Right. And so they're just wondering if they need to add any special
I would add
language.
special language to the notice. Number one, you have to add the language that says, if it's not already contained, that when counting the 3 days, do not include Saturdays, Sundays, and legal holidays. And also I would put into the notice that I have received no communication from the tenant as to the reason why April's rent was not paid. We're putting that into our notices.
Great, there you go. And Jason on YouTube, how do you go through evicting a tenant that has an unauthorized occupant living in the dwelling? What sort of proof is required by the courts?
You would, again, not the city of LA, but every place else, you would serve a 3-day notice to perform or quit, giving the tenant 3 days to get rid of the unauthorized occupant. After the 3rd day, you have the right to bring forth an eviction. A lot of people think that because I'm going after an unauthorized occupant that I can still take rent. Nothing could be further from the truth. Once you serve that 3-day notice to perform or quit, after the 3rd day, do not accept any rent. By accepting rent, you would not be able to proceed forward with your eviction. The question goes on to state is, how do I prove it? Well, you got 2 eyes, don't you? If you see the same person there, you know, in the mornings and the evenings, maybe you saw the guy using his key to go in, but it's the same guy. Maybe that guy drives a Tesla, and you see that Tesla there overnight. Well, wherever the Tesla is where your tenant is. Just like everybody listening to me now, your car, ladies and gentlemen, is right outside, just like my car is right outside. So on that basis, if you see the car, that's a pretty good indication that the stranger is still there. Again, we can't do that for the city of Los Angeles. Now, in the city of Los Angeles, or any place else, if you did rent, and I'll give you the example, if you rented to, let's pretend A and B, and somewhere in the middle of the tenancy, C moved in, and then A and B eventually moves out, even in the city of Los Angeles, you could bring forth an eviction to evict tenant C because, or occupant C, because that person's not your tenant, it's never paid you any rent.
Great. All right, Ming Chen on YouTube. Please explain SB 487 bill that would provide financial relief to landlords excluded from COVID-19 Emergency Rental Assistance Program. It has been approved by the California Senate Housing Committee.
I'm not familiar with that code section. I do not believe that it's been instituted yet. When it is, then usually I go over these code sections.
Okay. Okay, can you please speak to the proposed deal in Sacramento to extend the eviction moratorium, so 2179?
Right. I'm not. It could pass. I'm not really up on the full aspects of it again because it hasn't passed yet. But they're thinking of extending it to the eviction moratorium until June. In terms of, my understanding is that it really has very little to do in terms of us going forward with evictions. What it's doing is extending the rent owed from October through March to October through the end of June. But it also does another fact, if it passes, which would prevent other municipalities extending their eviction protection past June. So that could help us in the city of Los Angeles, which is extending incredulously till April of 2023. But again, it hasn't passed yet, and when it does pass, you can check obviously the AOA website or my website, Evict123, and I'll have all the details.
Great. Can a landlord, Kevin on YouTube, can a landlord give the notice to move out tenants in LA County without any cause?
And the answer is no, you cannot. You're going to have to wait at least until January of 2023 for the county. Now again, we're excluding the city of LA, forget it. But in the county of LA, I cannot just serve a notice until at least January of 2023 for most situations. There are some exceptions, which is low-income tenants below the 80% below the average medium income. That would still continue until June of 2023. But for most instances, it's all opened up as of January of 2023 for the county of Los Angeles, but not before.
Okay. YouTube, House Buyer Guru. Can we evict for non-payment starting in April in LA County, or are we stuck until 2023? You covered it, but yeah.
Okay, well, in LA County, excluding the city of LA, if your property is subject to statewide rent control, you have 5% plus the CPI, which is currently 3.6, or a total of 8.6. If your property is subject to LA County rent control, that is, your property is located in an unincorporated area of the county of Los Angeles, so you're not in a city, no rent increases are allowed at this time. I think they're extending that until January of 2023, so no rent increases. Now, you want to hear something? If you have rent control property in the city of Los Angeles, can you increase the rent? Well, normally it was like 3% per year. And the answer is no, you can't. Well, when can you increase the rent? I mean, I haven't had a rent increase in such a long time. I mean, going back for 2-3 years. Well, you can immediately do it as of April of 2024. April of 2024. So we're like 2 years away from a rent increase in the city of Los Angeles. Doesn't matter that, I don't know, that inflation and things are going up, makes no difference. You can't increase your rent for rent control properties in the city of Los Angeles.
All right, Bobby on YouTube, thanks for your question. Oh, went away. That's okay. Brandon, can you let me know if Hawthorne, Inglewood, or Long Beach is subject to rent control? Because it is not when I purchased.
Those areas are subject to statewide rent control, assuming the property was built more than 15 years ago.
All right. HRG, California Rentals. Are there any rent increase restrictions in Riverside for single-family homes?
Other than that anti-gouging, you can raise the rent to market level. Again, if you're going above 10%, it's a 90-day notice. Okay,
here we go. Martin, rumor is City of Long Beach rent relief is out of money and is simply sending out email messages that your status is new. What can be done for lost money?
Well, if the state doesn't give you the money, then the tenant is ultimately responsible, but you're going to have to wait a year before you can even bring forth an unlawful detainer action.
All right. Here we go. Feed the Triangle. Commercial office space. I'm Manhattan Beach. Tenant didn't pay rent for 3 months during the first months of the pandemic. Was this rent relief allowed for commercial office space?
It was under the county rules. You couldn't evict for non-payment of rent. And once the county ordinance is over, they had I think it was 3 months once the county ordinance is over that you can go back for the back rent. But as to the future rent, you can serve a notice for rent in the county for commercial from February forward in time. So if your tenant doesn't pay you the rent, serve a 3-day notice.
All right, Lawrence, when can we raise rent in San Diego?
Well, if you're not under rent control, then you certainly can raise the rent in San Diego, like a single-family home, townhouses, condos. You certainly can raise the rent. Otherwise, you have to deal with the San Diego statute, which does have a limitation on rent increases.
Right, and you can call the AOA office that's in San Diego, and they can point you in the right direction for sure. All right, Debbie, is Maywood area subject to LA County rent control? How do I find out?
Okay, well, Maywood is a separate city, so it's not unincorporated. So you're not under the LA County rent control. You might be under the LA County pandemic eviction protection, but you're not under rent control for the county of LA. Okay. You are probably, if it's a multiple unit built more than 15 years ago, you would be subject to statewide rent control.
Okay. Anthony, if I have applied for housing as key, but my tenant is not cooperating with the program, or they moved out with a large balance owed, is that money lost? It's RSO and Van Nuys.
Well, if they moved out, the money isn't lost. It's just going to be very hard to find because you're not going to be able to bring forth a civil lawsuit until April of 2024. So then you could file a small claims court lawsuit, but then you're going to have to serve the tenant, and I don't think the tenant's going to leave a forwarding address.
Right. And no option. Is state rent control 1482, which we need to put in the lease?
Okay, if your property is not under any rent control, or your property is subject to statewide rent control, then that has to be contained into any rental agreement that is entered into now.
Right, so that's in the AOA rental agreement, and just about any lease that's out there is going to have that in it, unless you're getting it off like a nationwide website that's not up to date. So here we go. Rob, how about mobile home parks? Are we required to continue applying for rental assistance with housing as key?
Well, yes, through March of 2022, this month. Yeah, you're subject to that same statute.
Yeah, so today's your last day, basically.
Yeah, good luck.
Get it in.
But don't run to do it until at least this telecast is over.
Why is that? Oh, yeah, you want them to finish.
Yes, finish, right? Of course.
All right, Daniel, in unincorporated LA County, Hacienda Heights, can we now raise rents?
If this is multiple units, if you're subject to LA County rent control, the answer is no.
All right, Mark, can I move into my single-family home in Hermosa Beach, June 1st, 2022? How do I do this? Tenant didn't want to move in 2021. I was told I could not, and then I could, but would cost me money. Please help.
You're under the LA County Moratorium eviction protection. You can move into your own home, assuming you bought that home prior to, I don't know where they got this law, prior to June 30th, 2021. So assuming you bought your home prior to that, you can move into your own home. Wow, what a concept. I can move into my own home. But you have to pay relocation money. The relocation money is anywhere, I actually have it here, anywhere from $7,600 up to about $17,000, depending on how many bedrooms and whether your tenant is a senior citizen.
Wow. All right, Shoab. Single family home, unincorporated LA County, partially covered under LA County RSO, exempt under state rent control. Tenant's lease ends 6/30/22. Renewal sent 90 days prior to lease expiration. What if tenant refuses to sign?
It says it's under RSO for the city of Los Angeles. If the tenant...
unincorporated, so LA County.
Well, it says, am I reading the wrong one? Oh, I'm reading the wrong
yeah,
question.
top one. Single family
let's try
home.
that. Again, unincorporated LA County. It says it's partially covered. I have no idea what that means. You're either covered or you're not covered. A single family home with only one house on the lot would not be under LA County rent control. You are allowed to raise the rent to market level. If the tenant refuses to sign a new lease, that would be grounds for eviction, even under LA County rules that you could bring forth right now.
So the LA County resolution that they passed on January 25th does not apply to single-family homes in LA unincorporated.
Well, it applies in terms of that you have to have a reason to do an eviction.
Okay, so yeah, the difference between eviction and raising the rent.
Right.
Okay, so you can raise the rent, you cannot evict.
Yeah, you can always raise the rent on a single-family home.
Okay,
You just don't have to pay it to you.
They still owe it. They still owe it, right? So, Catherine, for City of LA RSO, are we able to proceed with small claims actions? My tenant has already reached 18-month assistant limit and is continuing to not pay rent.
As I stated, under small claims, under the City of Los Angeles, that rent is not due until April of 2024. So you can't bring forth an action until rent is delinquent. Rent's delinquent in April of 2024.
Okay. Okay. Mahnaz, rent control apartment in City of San Diego. Tenant did not pay for close to a year from just before COVID and all during COVID times 1 year. Was evicted. Can I apply for reimbursement from state city? Thank you.
Absolutely. You can apply. The tenant is ultimately liable, and the fact that he's been evicted doesn't change anything. You're entitled to that you're entitled to compensation under the rent relief program.
And I believe San Diego City has a different program than the housing. They have their own specific program,
Right.
so you'll need to look into that.
Right, but it is still administered by the state.
Right, administered by the state, but it's not housing its key. It's going to be something, it's going to be different, but get on it because today's probably the last day for that one too. Not sure. And John, on YouTube, what are the rules in San Diego County and City of San Diego regarding serving a 3-day notice?
Well, I don't think there's anything different right now. As of April, you can serve a standard 3-day notice and proceed forward with the April's rent. There's no requirement that you apply for rent relief for the month of April. So I'm recommending at this point in time that even if the tenant owes back rent prior to April 1st, do not include that. Just go for the April's rent and forward in time. We know in LA County they have the right to self-certify, but in most jurisdictions you can just serve a standard rent 3-day notice for the rent for April and thereafter.
Okay, great. Okay, Andres, doesn't the recent state extension of the eviction moratorium through June 2022 from a few days ago, this is the AB 2179 again, preempt the LA County moratorium that protected non-payment of rent starting 4/1/2022?
Well, that
question,
2179 isn't law yet, so...
So if, let's say that it's signed today.
Let's say it's signed today, then that there was a provision that would trump LA County and LA City.
Would it even trump LA City?
Yes.
Okay. So,
because part of that law stated, and again, I haven't studied it in totality, but it did state that it's going to prevent other municipalities from extending beyond that date.
Yeah, I read it a couple times, but these things, you got to read them over and over and really think about it and process it. So
you don't really want to spend too much time because you never know what's going to happen or if it's going to be changed. So
right, yeah.
At the last second.
Today it might get changed, so hopefully it doesn't, in the sense of wiping out all the complexity.
Well, it will be much better for the city of LA because I really, even though, quote, my plan doesn't really cover RSO properties. It only covers non-RSO properties that where the tenant's on a month-to-month. Now, that's a lot of cases, but it's not the majority of the cases. The majority of the cases, hey, I've got, RSO property and my tenant hasn't paid in a month of Sundays, literally. And in that situation, your only hope is that this new state law will change the city law.
Okay. Danny, be good. Unauthorized pets and occupants not allowed as grounds for eviction in LA County right now, as long as tenant says it's because of COVID.
Well, this is not a self-certifying situation. So if in fact that you need extra people or you need pets and it's due to COVID, then technically you can't bring forth an eviction for the County of Los Angeles. But let's think about that. I brought a dog in, and I brought a dog in because of COVID. Does that make any sense? I brought a person in because, let's pretend I have COVID and I brought a person in to help me and my kids because I have COVID. That's legitimate.
Yeah.
But other than that, if I don't have COVID, why do I need that person there? And it's not that the person who is coming in has COVID and I had to take care of him. Because if that was the case, then everybody in the world who has COVID could move into your unit. That's not what the statute was referring to. It's that the tenant had a need to bring in an extra person because of COVID. So there are some examples, but very few. So if you've got extra persons in violation of the rental agreement, if you've got pets in violation of the rental agreement in the County of Los Angeles, excluding the City of Los Angeles, we can do an eviction.
All right. Okay, Cray. Does the state rent control for LA County properties prevent us from a 3-day with the 7-day delay to wait for a self-certification of COVID impact?
The answer is yes. You don't want to serve a 3-day until, for strategy purposes, you don't want to serve a 3-day until the time has passed. Could you serve a 3-day notice on April 2nd? Yes, but then that tenant's going to run to his attorney who's going to say, quick, instead of paying the rent, self-certify that you're affected by COVID. So the strategy is not to serve it until, for the month of April, until April 11th. April 11th, serve it. I didn't get a certification from the tenant. And again, he can certify it anyway without any proof. Just open up your mouth and say something. Then you cannot proceed forward.
All right. On Facebook, Ellen, I see that the Fair Housing Act exempts owner-occupied buildings with no more than 4 units and single-family houses sold or rented by the owner without an agent, that they're exempt from renting to tenants with service dogs. Have you heard of this ruling?
I have not heard of that ruling, and I don't see how. Yeah. I don't believe that is accurate.
I wouldn't rely on that one either.
Nope.
Okay, Jesse, you mentioned family member move in, but what about owner himself move in? Do we still need to pay relocation fee?
And the answer is yes.
Yep.
Yes, whether it's a close family member or even yourself. And by the way, in the County of Los Angeles, incredulously, if you bought a home after June 30th, 2021, and you want to crazy, you want to move into your own home, and there's a tenant there, you can't unless you pay substantial relocation. If you wait until January, then you'll be able to do it for no relocation at all.
All right. Jesse, you mentioned family member move in.
No, that one we did.
Okay, we already did that one. Okay, Adrian, what happens if the tenant does the self-certification after we post the 3-day notice?
Well, if you wait till April 11th, that's my plan. If he self-certifies after you serve the notice, it means absolutely nothing. You can proceed forward with an eviction.
All right. And maybe a better way to ask the question is, what if they're self-certifying just in the right time period.
Then you
Didn't say
cannot proceed forward with an
you had to
eviction.
wait. You have to wait until 2023 to collect
Correct.
on
You'd
that,
have to
yeah.
wait.
Right. Okay, Vincent. For a mobile home in LA County, does a landlord need to pay relocation fees when asking a tenant to move for family member use?
And the answer is yes. Mobile homes are part of the statute.
Okay, Michelle. Is there anything specific about Orange County? The question here is a little hard to know what she might be referring
Well, in
to.
Orange County, with the possible exception of the city of Santa Ana, which started their own rent control, your property probably is subject to statewide rent control. If it was built more than 15 years ago and is not a single-family home or a condo or a townhouse. So you can certainly serve a 3-day notice for the rent, for the April's rent. You can do that on April 2nd. You can ask if it's not subject to statewide rent control, you can just serve a 60-day notice or a 30-day notice if the tenant's on a month-to-month tenancy. If the tenant is subject to statewide rent control, you do have to have a reason to evict. One reason would be that I want a family member to move in. If that's the case, you have to give relocation money, which is 1 month's rent. The easy one would be just that you want to renovate the unit. And if you want to renovate the unit, you could serve the tenant with a 30 or a 60-day, depending on how long they've been there, and comply with the renovation rules.
Great. And you mentioned some of the state stuff at the beginning, and then next week also we'll have another attorney from Alameda area, and he'll also speak to the state things. And yeah, so it seems like Orange County, that's where it's gonna fall under that. I have a rent control unit where my tenant has not paid since the moratorium, and I need to apply for rent relief. I also want to evict him for moving a family into the unit and subleasing without my knowledge.
In the, I don't know where this is. If it's the city of Los Angeles, you can't do anything. If it's the county of Los Angeles, again, you can serve a 3-day notice for the April's rent and proceed forward. If it's the county, you can move in a family member, but you got to pay relocation money, which is substantial. And also, lastly, in the city of Los Angeles, well, it's under rent control, so it wouldn't work for the city of Los Angeles.
Okay, I have a rent control unit where my tenant has not paid rent. Did we just do that one?
Yeah.
Yeah. Okay, let's see. Unincorporated Hawthorne falls under state, city, county.
Well, if it's a multi-unit building, it would fall under the county of Los Angeles rent control. If it's a single-family home, then you would not.
All right.
Under any rent control.
Okay, Otimus. Can I still serve a notice of non-renewal and evict if the resident refuses to move out and they have yet to complete their full year?
If the resident refuses to move out and they have yet to complete their full year. Okay, so in the county of Los Angeles, you can't just ask a tenant to move because their lease is over, and if they're on a month-to-month tenancy, you just can't serve a notice to quit. In the city of Los Angeles, you can't do that either. Now, if you're in a civilized place where you own property, like Orange County, Ventura, San Bernardino, Riverside, then you could tell the tenant in a letter, an informal letter saying, hey, you know what, your lease is over as of May 31st, and I've enjoyed your company, but I'm not renewing, and please vacate.
Yeah, I have a question. You know, back to your secret plan that's no longer secret.
Mm-hmm.
So let's say that the lease agreement stipulated it was just a 1-year term lease agreement that didn't say that it automatically goes into a month-to-month afterward. With that kind of lease setup, would it be the same as a month-to-month?
Yeah, under California law, if a lease expires and the tenancy continues, it becomes a month-to-month on the same terms as the as that lease.
Mm-hmm.
Again, once the lease is over, I can raise the rent, assuming I'm not subject to a rent control statute, or raise it pursuant to that statute. But I can always get a 30-day notice to raise the security deposit, and if the tenant doesn't pay that amount, then I have the right to evict.
Right, okay. Okay. Anquanette, I rent out a single-family home in Los Angeles. The place where I currently reside has become dangerous for me to live. I received a restraining order against my neighbor. Can I evict my tenant?
So you want to evict your tenant because where you're living is a dangerous place to live, and you actually had to even get a restraining order. And I can tell you that the City Council of Los Angeles and the mayor doesn't give a damn about you and your situation. And even though your current tenant in a single family home, not subject to any rent control, where if the tenant wanted to leave, he would just give you a 30-day notice, you have no right under the city to ask that tenant to move and just terminate the tenancy. However, we can use the plan that I came up with, where we can certainly raise the rent. We can also raise the security deposit. And even though the tenant might not want to pay the rent, he does have to pay the additional security deposit, and we can use that as a ground to evict.
All right. I bought a duplex in San Pedro under RSO. The tenant pays 52% under market value. Can I go to the Rent Adjustment Commission to request for a buyout and relocation of the tenant?
No, there is no such thing as asking the tenant for a buyout. You can go, even though they won't do it at this time because there's no rent increases at this time, you can ask the City of Los Angeles for a just and fair return. And if they determine, which they won't, that your rent is way under market value, they could, but they won't, issue you a rent increase above what the current allowable rate is. Right now, the current allowable rate is 0. It's a 0 rent increase. So there's really nothing that you can do in that situation. My only suggestion would be to go to that tenant who's severely under market and offer the tenant a buyout. We assist landlords with what we call voluntary vacate agreements. There are certain requirements and forms that we have to file with the city, but it's worth it if it's way under market value. You know, it's worth it to offer a tenant $10,000, $20,000, $30,000. I myself had a tenant move where we paid them $37,000. It sounds like it's a lot of money. That tenant was paying me $995, and I am currently getting $5,500. So my return on my investment was unbelievable. So you just have to do the math. What can you get for your unit if the tenant vacates? And how much is that worth? In most situations, you can put down a substantial amount of money, and if the tenant is willing to accept that, it generally is always in your interest to do so.
All right, Vika, is there any action that can be taken in the city of West Hollywood? Tenant and landlord applied to payment from Housing is Key. Tenant is on a 1-year lease.
Well, if the tenant fails to pay the rent come April, and the tenant hasn't self-certified, then we can proceed forward with non-payment of rent for the month of April.
All right. Cheryl, what do you think City of LA will change the April 2023 date to an earlier date?
I think the answer is never. They will never change. If they're forced to change by the state, then they'll do it, but they will never move it up. And again, no one now needs protection from COVID, from being financially impacted. No one. Anybody can get a job now. No one is impacted. This is insanity by the City of Los Angeles.
Right. I mean, the fact is that Housing is Key is there for them to get the assistance that they need. So really a ban is not ever, there's no ever need for a ban, ever.
In addition, really, in so many cases, more than 50%, the tenant either doesn't qualify or hasn't applied, one of the two, in more than 50% of the cases. So in that situation, a landlord can do nothing, zero, until April of 2023. Again, 39 months or 37 months without payment. And again, I only have this one solution which deals with non-RSO property.
All right. When can rent be raised in LA County properties?
Right now, there's a ban on rent-controlled units in the county of LA. I think that's extended until January of 2023.
Okay. Okay, so UB Sanchez, I serviced a 60-day notice to vacate for renovation with Dennis and lost due to motion to summary judgment. I'm still dealing with that tenant. What other options would you suggest?
Well, I would have to know more about that. One of the reasons why we could not prevail on a renovation is that the county in the middle of our case changed the law. So because of that, and it was retroactive, we had no chance. It's kind of like playing baseball and your team wins at the end of 9 innings, but then the umpires change the rules and say, no, it's a 15-inning game. So we had the rules changed in the middle. So, but for that person who wrote that question, please give me a call at the office and we'll put our heads together.
All right. For unincorporated LA County, if a tenant in which we just had to add a family member to the rental agreement, does it change the ability to raise rent since we are executing a new agreement?
If your property is subject to LA County rent control, the answer is there is no rent increases allowed at this time.
So even for adding occupants, no rent increase?
No, nothing.
So, Benjamin, I have a tenant now month to month, but my property is under rent control in the city of LA. If tenant does not pay for April and following months, what can I do?
There's really nothing that you can do. You're under rent control for the city of LA. You have to wait until April of 2023. So if you can't get any rent relief from housingiskey.com, then you're basically like the situation that many of my clients and other landlords are in. You're just into a big financial loss with no hope of recovery.
Okay. All right, we have Eric. We purchased a 4-unit property with the intent to move into one of the units with my family. We used my VA home loan benefit to be able to purchase this place in the county of Los Angeles in a city that doesn't fall under rent control. According to the county phase 1 and 2 protections, we are not allowed to move into our new primary residence until January 2023 and following a 60-day notice. Phase 1 and 2 only apply to 3 units. And then Beverly, Melody, can you move that up to see the rest of it?
Well, let's just first take that before we move it up even.
Okay.
If you bought the house after June 30th, 2021, there's a ban on a family member move-in until January of 2023. So you're just out of luck. And they say, but I bought a home through the VA, and part of the VA, it's federal, says I have to live there. Well, the city of Los Angeles doesn't care about you, doesn't care about your VA loan, doesn't care about your lender, doesn't care about anything. You can't, or excuse me, the county of LA doesn't care about that. Any help for the city, for the military? And the answer is really no. There's really nothing that you can do until January of 2023. You might try to, and I'm assuming you bought the house after June 30th, 2021. If you didn't, if you bought it before, which is unlikely, then you can have your tenant move, but you'd have to pay substantial relocation.
Right, so Edward.
We're going to do a couple more.
Yeah, okay.
As we're getting to the time.
And then where did Edward go?
We lost Edward.
There he is.
There he is.
Okay, I'd like more information on the existing lawsuits on the city from the small landlords. And so I don't know if there's a one from small landlords on the city. There's a $20 million case with Jeffrey Palmer. And then we have a AOA and another association. We do have one against the county, and then there's other ones that are against the city. But do you know of a small
I'm
landlord one?
not aware of those. The ones that you just referred to are the ones that I'm aware of.
Right. And so,
But I don't think it makes a difference between small and large.
yeah, that doesn't matter.
And if Palmer's case wins, then everybody wins.
Right. Yeah. And so that's kind of what we've been waiting for that one and hoping for that one. It's just taking forever. And so we did file the one against the county, hoping to get an injunction. And we're going to find out about that and see what happens. But the main premise of these is the whole, it goes around the self-certification aspect. And when a tenant self-certifies and say, oh, it was COVID, and there's no third party to verify that, then that's denying due process of law for the housing providers. And so especially, housing is key, or these rent relief programs, we're kind of making judgments. Well, are you at 80% of area and median income or not? And so there was something there, and as of April 1st, because that goes away, there's nothing. It's just say it if you want to, and in LA it's been like that. So it seems like these lawsuits should have been over a long time ago in my mind. It should have been really clear cut. But you have, maybe judges that just are activists. I don't know what to say.
Crazy.
Hard to see it. So maybe one more?
Yeah, it's a good one.
Okay, Race Owen. Dennis, how quickly can we evict a former homeowner after purchasing the home at foreclosure, trustee sale, auction? Riverside County, City of Coachella, and San Bernardino County, the City of Joshua Tree.
Regardless of where you are, if you obtain title to a property by way of a foreclosure sale where you have a trustee's deed and that deed is recorded, you can then serve on the previous owner a 3-day notice to quit and proceed forward with an eviction. We do a lot of those cases. There is no protection under the law under COVID for that type of a situation.
Okay, I remember somebody, like a family, not being able to get in.
There was one where somebody sold the property and the previous owner refused to get out. That one took a long time because it was during COVID and they weren't allowing any evictions.
Okay. All right. Well, everyone, thank you for all of your questions. We know you have a lot more. Call his office, call Dennis Block, and he'll help you out. And also there's, so that for sure. Tomorrow our rates go up for the Apartment Owners Association. If you want to extend your membership, or if you'd like to sign up for the first time, today's a good day to do it. You can do that online. Go to aoausa.com and just hit the join, and you can do that online real simply. And anyway, don't forget 1 o'clock. We have something going on with having the housing is key person in. And then next week, how to attract 67% more potential tenants for free. And that one, really, there's no strings attached at all. And the NorCal legislative update next week. And don't forget that resident manager litigation YouTube that we did last week, and really good. If you have an on-site manager, or you have people working for you on W-2 with your property, you're definitely gonna want to watch that. And anyway, thank you, and we'll see you next time.